Lisa Ann Luton versus Andrew Michael Luton.
All right. We have a number of motions and a number of responses to motions. This shows on the docket that this case is set for final hearing. And then I also have a motion to compel discovery, a motion to appoint a guardian ad litem, a respondent's motion, which was filed November the 10th of this year. Then I also have a motion to strike the petitioner's notice of final hearing, a motion to compel the respondent's interrogatories, a request for production of documents, motion to dismiss, plaintiff's motion to modify the parenting plan, and request for ex parte order for immediate return of the child. And then on the 10th, I have a motion filed by Lisa Luton to strike the father's response to appointment of the guardian ad litem from the record and strike notice of the final hearing. Somebody want to tell me what we're doing exactly? Because it's confusing to me, and I've looked through the file. So.
Yeah, sure. So we did a notice striking the final hearing just because we had received an email from Ms. Davis back in August that she was going to enter a notice of appearance for Mr. Luton. When we inquired with the clerk's office a couple weeks ago, they said that there wasn't one. And so at that point, we're like, let's go ahead and strike in that final notice, the final hearing, because we weren't sure exactly what was going to happen. Additionally, you're the only judge in this district who can hear this matter due to conflicts with the other judges.
Lucky me.
I'm sorry?
Lucky me.
Yes. And so we had filed our motion for guardian ad litem back in June. And unfortunately, due to your other court obligations with the murder cases that you had this year, this was your first date after I filed that back in June. So upon speaking with my client, she felt that that was something that we really wanted to move forward on. So we went, in addition to trying to figure out what exactly was on the motion for today, we decided that was going to take precedence over moving forward with the final hearing. As far as I think that's our only, we have the notice striking final hearing, so I don't believe that we intend to move forward with the final hearing. I believe Ms. Davis is also filed a motion striking the final hearing, so I don't believe we're going to move forward with the final hearing today. As far as all the other motions, I think we ought to maybe take them one by one. I believe Ms. Davis has also filed a motion striking all of Mr. Luton's pro se motions. I'm not sure if those are all of his motions and his responses or just his motions.
I noticed that your client had filed a number of pro se responses to motions and so forth. Ms. Roberts, did I understand correctly? You're filing a motion to strike his pro se?
Yes, Your Honor. If I could, I'm late to this party. Mr. Luton, when the petition was filed, Mr. Luton sought to represent himself and proceed pro se. After some issues that came through, he came in and retained me after this matter had started. So basically what I would like is kind of get the lay of the land from the court, first of all, to determine what we're here on, because this is a unique situation.
I'm asking you all what we're here on. So.
If I could, just to go going through the record, these parties were just divorced in May of 2020. At that point in time, they were both represented by counsel. Mr. Luton had another attorney representing him at that time, and I think the Baptist firm was involved in representing Mrs. Luton at the time. And an agreed marital dissolution agreement parenting plan was entered by the court, and it was filed with the court on May 22nd of 2020. The parenting plan that was entered at that time was an equal parenting plan. A little unique schedule in the respect that they had a parent 1, parent 2, and this child went Sunday to Tuesday with one, Tuesday to Friday, then Friday to Sunday, and then so it's kind of a rotating schedule that they have. The ink was not dry on the final decree, if you would, when Mrs. Luton's counsel filed a petition for contempt and to modify child support. So, Your Honor, if we could, that's the lead process that we have before the court right now. And that was filed on July 13th of 2020. In that petition, it's very succinctly drawn. And again, the prayers for relief are very set forth clearly. First of all, they allege that the parties were divorced on May 12th. They allege that Mr. Luton was ordered to claim his interest in the Ginger Drive property. They alleged he refused to sign it. They said that the parenting plan incorporated in the final decree, the parties had to provide the W-2s to one another. The husband refused to provide the W-2. The husband's actions were in willful and deliberate contempt of this court, that he obtained new employment, and that her income decreased, and that they asked for a modification. So contempt and a modification some less than 2 months after the petition for divorce was granted and the final decree entered. This is when Mr. Luton did not seek advice of counsel, and he filed a pro se answer on his behalf. The crux of the issue being the two contempt scenarios, which I believe are spelled out, him failing to sign a quitclaim deed and stating that he failed to provide a W-2. And again, he denied both of those allegations in the respect that he had signed the quitclaim deed on June 8th within the 30-day period before the decree became final, and it was done before the petition was filed. And then secondly, it said he had failed to provide his W-2. Well, again, I don't know which council executed and signed the marriage dissolution agreement parenting plan. But again, if I had been counsel, I would have filed Rule 11 sanctions in this request, because it clearly states that their W-2s were done in February, I think it says February or April, excuse me, they were supposed to provide it. And that had not come around yet when they filed their petition. They were only divorced in May, and there was no obligation for Mr. Luton to give a W-2 that was non-existent. They would have had that in prior discoveries when they calculated child support. So again, that allegation in the complaint is volatile to Rule 11 because it failed, it's inappropriate, and there was no requirement for him to do so. Then the last one was he obtained new employment. That is a true factor, he did, and he provided that information. And as far as I understand, Mr. Luton has voluntarily increased his support without court order because he has had a significant change in his income. So at that point in time, the petition was there and he filed a response of pleading, and then counsel served interrogatories to Mr. Luton, which will get that are uniquely, obviously, irrelevant in big part, but he didn't have counsel and he didn't file a motion to strike. These interrogatories asked Mr. Luton 2 months after a divorce, which counsel for the petitioner at the time was involved and should have done discovery, asked for W-2s and 1099s. He would not have had one from May of 2020 till July of 2020. K-9s. He then asked, did you file a federal tax return in the past 36 months? They had just completed the divorce 2 months shy of the request for these production of documents. And then they asked, number 3, documents that reflect the purchase price and cost for improvements and fair market value of real property. Again, Your Honor, it's irrelevant. Had he had counsel, they would have filed a motion to quash this interrogatory because it's not relevant to the fact of signing a quitclaim deed, producing W-2s, or in increasing child support payments based on an increase in income. Evidence of ownership of stock and partnership, bank statements, canceled checks, statements on accounts of all liquid assets, copies of certificates of deposit, statements of individual retirement accounts in the last 36 months, each and every retirement plan that you have, appraisals on real property, personal or mixed in the past 60 months, all personal financial statements in the past 36 months, all medical records in the last 10 years are in the alternative, your treating physician and assigned HIPAA waiver. Admit or deny the documents you provided in the request are genuine documents. So this is what Mr. Mathis filed on the basis of a motion for contempt for failing to sign a deed, failing to give a W-2, and an increase in child support. Mr. Luton, on his own, filed a pro se answer to the request for discovery, refusing to answer the first set of interrogatories. He then appropriately and inartfully filed that with the court rather than asking for a protective order. He just said, I'm not answering them. the court deemed that is not appropriate and ordered him and compelled him to answer discovery. And again, Mr. Luton, on his own behalf, you granted on April 8th of 2021, you granted a motion to compel the discovery. You gave him 30 days to respond in writing, and he reserved the issue to compel based on, whatever answers he provided. He filed documents with the court and with counsel, again, while he was pro se. Then at that point in time, Your Honor, Mrs. Luton filed a motion for custody that is not tied to the original petition. And hence comes my first motion that I think would be relevant, is my motion to strike and to dismiss that motion as it's not properly filed.
You're referring to the motion to modify parenting plan and request for ex parte order for immediate return of child filed February the 8th of 2021?
Yes, Your Honor, that's inappropriately titled. There's nothing in the original petition that is the contempt and the modification support that would allow a motion to be filed modifying the parenting plan. There's no allegation of significant material change of circumstances or best interest determination. That cannot be filed by motion. It's inappropriate before the court, and as such, should not be allowed to go forward. If they want to amend their petition and allege a significant material change of circumstances, then certainly that would be appropriate. So that was number one. Number two, the issue on the guardian ad litem, there is no allegation before the court, properly before the court, of a modification of child custody. Therefore, guardian ad litem is inappropriate. There's no need for a guardian ad litem when you're asking for a modification of child support, a contempt on the deed, and a production of the W-2. Then, as we go forward, Your Honor, my client felt it appropriate to simply copy counsel's interrogatory requests and resubmit them back to them. And again, as an officer of the court, I do not want my name attached to those. And so they're not appropriate. Now I have gotten answers to somewhat, but what's uniquely about this case is they objected to them as irrelevant.
And I would just also add, though, that Mr. Luton sent them directly to Ms. Luton. They were never sent to counsel. And that had been, we just basically said that needs to be directed through counsel. And we never actually received a copy. They were sent directly to Ms. Luton, which was improper as well. So yeah, it's just a mess.
So again,
We're going to fix the mess.
Yes, that's our goal today.
the goal is to fix the mess. So again, they sent interrogatories that I would have objected to had I been counsel. Mr. Luton did not. He just refused to answer and then sent them identically back after he has made accusations before the court that they were irrelevant. I agree, they're irrelevant, they're nonsensical, and they need to be stricken, and we need to go back to square one on everybody's discovery request. But again, I'll leave that with the purview of the court in that. So we get to that point is that they had not answered the discovery. But as an officer of the court, again, I just find it somewhat comical that they said their interrogatories were irrelevant. So at that point, we moved forward. So what we're looking at, again, then my client thought it was appropriate to file a petition for contempt and a motion for sanctions to failure to answer discovery. Again, that's inappropriate, and I ask that be stricken.
Why don't you let me fix the problem and let's just go forward from there.
So that's where we are.
All right.
I think that's what we're asking today, Your Honor. And if our motion is improper, we would just move to amend our petition.
All right. Here's the ruling of the court. Mrs. Roberts is correct that a motion to substantially alter the parenting plan must be a pleading that either refers to the original pleading, which began under the rules of civil procedure. A matter can be begun by filing of a complaint or a petition. There was a petition filed post-divorce. That petition dealt with those three issues that Ms. Roberts has identified. I've reviewed the file and I agree. It did not include a request for modification of the parenting plan per se, so therefore a subsequent motion would not have related back to anything that was pending. But to fix that problem, because it's illogical for these parties to thrash around and then have to come back into court on a new pleading, we're just going to put an order down that allows Ms. Luton to file a motion to amend, which the court will grant, her request to amend her original pleading in this case and allege whatever it is that she chooses to allege. At that point, then, the court will order that any discovery requests that have been previously filed by either party are null and void, and that we will start fresh with this new amendment, because at that point, there may be additional issues that need to be addressed, so that Ms. Luton files her motion to amend, alleging whatever she wishes to amend, or to allege, rather. So is that on Ms. Roberts. Ms. Roberts, will you accept service?
Well, Your Honor, I will agree, if Your Honor will allow, that her oral motion to amend is granted. There's no need to file a formal motion to amend. I will stipulate and agree that she has made an oral request to amend her
You
petition.
making an oral request to amend your petition?
Yes, Your Honor.
All right.
And so I agree with that. And so she can just file an amended petition without the necessity of filing the motion.
Then let's do one order that says that the matter came before me today, and that due to confusion in the record, that the court is putting the following order down, and that is on your oral motion, then you will be allowed to amend your original petition to raise any additional issues. That will be served on Ms. Roberts, and she will accept service of process, and she will have 30 days to file her response. All discovery requests that have been previously propounded by either party are held to be null and void, and any future discovery will take place after the filing of the amended petition. In addition to that, the request for a guardian ad litem court finds to be premature, and will reserve it if you wish to refile it after the filing of all of the amended petition.
So do you want me to go ahead and say that that motion is denied and that I will need to refile that motion?
Yeah, let's just do that. The motion for a guardian ad litem is
I think
denied.
your record is very clear, very clean.
Correct.
Okay.
Motion for guardian ad litem is denied as premature based on my ruling regarding the original petition and the motion, and therefore you can it's denied subject to being refiled and considered by the court subsequent. So it's denied without prejudice. There is an order of protection in this file.
So that, again, that concludes all of the chancery matters that were in that, and now this is a new matter with the order of protection that was filed on Friday that is now here on the show cause.
And I was not aware that that was filed by my client, Your Honor, and she and I have talked about that. We're not going to pursue that today.
So we were supposed to be denied. We're ready to go forward.
The order of protection is set for hearing as to extension. It was actually a request for, it was a show cause,
It's a
correct?
show cause. It's a show, but she filed a pro se order of protection. Your Honor did not issue the order of protection, and it's set for show cause
The
today.
reason that I did not issue it is because in reading through it, it appeared to me largely to be complaints about the interchange of parenting between these
Correct,
parties.
Your Honor, and that's, I think that will relate more to once we get the new petition filed and our request for like an
All right, so let's just, does either party have any problem? Well, in any event, I would like to make sure that the parties understand there'll be no harassment between either way, between these two parties. But calling, and it's also this court's opinion that calling and asking about picking up the child, if done correctly, is not harassment. But it can rise to the level of harassment, and the court will consider that at a final hearing. I'm not finding either way that there's anything, but this was set as a show cause for an order of protection. The court finds that obviously Ms. Luton is not ready and desires to not pursue that at this point. So the order of protection will be denied since there was not one issued, and we'll just reserve those issues for the final hearing in this case. Or a temporary hearing if the need arises.
And may I ask just for clarification, or in the parenting plan that the parties are traveling under has a right of first refusal. And I want to make sure that the record is clear in the respect that when one party, it states very clearly that when one party cannot care for the child during their time, that the other parent has the right of first refusal. So I just want to reiterate that it's still in the current parenting plan. So Your Honor just said if he calls to ask for the child, it may not rise to the level. And by the same token, it may rise to the level of contempt if there is not if you're not following a court.
I make no finding. My observation was about the wording of the request for an order of protection made mention of repeated requests, even though there had been no response or there had been a denial that there were repeated requests. I'm simply trying to keep these parties from harassing one another over this issue. The original parenting plan and the language therein remains in full force and effect until there can be a hearing before this court. These parties both have good attorneys, and they need to follow their attorney's advice regarding that. If there needs to be a clarification about this first right of first refusal, then I would hope that the parties can work out some sort of agreement. If not, then it needs to get set and get a hearing on that issue, if nothing else. But that's not before me today. The original order of parenting plan remains in full force and effect, and the parties need to be understanding that the court who hears this case, which apparently will be me since no one else can hear it, I will consider how the two of you behave towards one another, and that includes if it rises to the level of harassment in trying to exercise something that's set forth. Yeah, there's visitation and there's a right of first refusal. I'm not sure those things work very well all the time, but it can work if the parties cooperate. What I want everybody to understand is that it does not need to rise to the level of harassment. So let's conduct ourselves accordingly and make sure that when you come back before me, that there's not any other problems, because if there is, I will deal with it, and the only option I have been given is a hammer. There aren't many ways to modify these things and make it in a fashion that's subtle changes that work their influence. I have a hammer that I can use. I don't want to do that, but that's what I'll have to do. If that's what I have to do, I will do it. All right, so does that clarify everything, that we are now everyone's side, knows where we are on both sides of this equation?
I believe so. I just want to make sure and clear. So everything that has been filed pro se by Mr. Luton has been struck from the record at this point. That's what we're saying.
Well, again, yes. I mean, other than, no, his answer, again, we have the original petition that they filed. He has answered that.
That's the extent.
And
there was an original petition.
Everything after his initial answer, we are striking for his pro se responses.
As long as we understand that you reserve the issue of sanctions and attorney's fees on the motion to compel discovery. So as long as that, again.
I've held the discovery request to be null and void.
Well, I just want to make sure that we're looking at it, because there's a court order in there that says he shall do this, and the issue to compel.
But whoever that judge was obviously didn't understand the entire significance of this situation. I don't know. We're going to have to find out who it was and talk to him. But in any event,
I don't think he's retiring, Judge.
He is definitely not. I can tell you that we are not. There's not going to be, the motion to compel that I entered is now null and void, just like the motion for discovery are null and void. So we can start fresh. Let's get these folks situated to where the real issues between them are going to be brought before me, and I can try to resolve it. And hopefully we can keep the peace in between now and then.
So may I, on the last volley here, ask for your upcoming dates?
No.
Can I go behind your back and ask for those?
Let's when we recess court here, I will allow you to talk with Ms. McKinney and Ms. Turner and see what you can find out about it. So, all right.
Thank you, Your Honor.
Thank you.
All right, that will conclude this hearing, and then we'll let us see what we can find out. We're going to go ahead and break for lunch. Is that concluded?
We were in, Judge.
We were the last hearing.
All right. So we will go ahead and.
This courtroom wasn't arguing over who was right. It was trying to figure out what the case was even about. The judge admitted the file was so confusing that he asked both sides to explain what was actually happening. Lawyers argued over motions, discovery requests, and parenting issues, but instead of moving the case forward, everything became more complicated. Finally, the judge made a dramatic decision: wipe the slate clean. He allowed the petition to be amended, declared all previous discovery requests null and void, and ordered both sides to start over from scratch. But before ending the hearing, he delivered one unforgettable warning. He told both parents to stop turning every disagreement into harassment because, in his own words, "The only tool I've been given is a hammer." In other words, if the conflict continued, the court would step in with serious consequences.